Indian Regulatory Framework, Chapter 1. A regulatory framework is a set of laws, rules, and regulations that govern the conduct and operations of a particular sector or industry. It provides a framework for how individuals or organizations and companies must comply with certain guidelines and standards set by regulatory bodies or the government. Now, for example, we have safety standards, environmental regulations, licensing requirements, family laws, workplace laws, pay laws, etc. Now, regulatory framework governs conduct and operations of a particular sector or industry. It applies to individuals, organizations as well, which is written over here same. Now, what is law? Law is an obligation or a duty imposed by the government for the welfare of the society and to provide justice. Now, here in the introduction, it is given the history about law. For that, Code of Hammurabi is known for oldest law in written form. King Hammurabi ruled Babylon for a period of 1792 BC to 1758 BC. He carved the code on bulky stone slabs, placed those stones on different places all over the city. He also appointed judges to check whether public is following the laws or not. In 450 BC, a set of laws was engraved on 12 bronze tablets in Rome, which is considered as first most detailed code of any of the civilizations and are called 12 tables. The purpose of these tables was to protect the rights of public and to provide remedy for wrongs. Now, after introduction, what is law? So, law is a set of obligations and duties imposed by the government for securing welfare and providing justice to society. India's legal framework reflects the social, political, economic, and cultural aspects of our vast and diversified country. Now, there are basically four sources of law over here, which are the Constitution of India, statutes or laws made by the Parliament, precedents or judicial decisions or customary law. So, CSPC. Okay, CSPC. Now, let us read it. The main sources of law in India are the Constitution first, the statutes or laws made by the Parliament second, and state assemblies third, precedents or the judicial decisions of various courts, and in some cases established customs and usages, which is the customary law. Fourth, now, you must be aware that India is a parliamentary democracy. We have a constitution which is the basis and source for all the laws. We elect our representatives to the parliament as well as to the legislative assemblies of various states. These representatives of the parliament make laws in parliament or in their state assemblies as the case may be. So, parliament is the ultimate law-making body. The law passed by parliament may apply throughout all or a portion of India, whereas the laws passed by state legislatures apply only within the borders of the states concerned. The Government of India Act 1935, which is written over here. So, first of all, let us understand about India's federal system. So, it is federal in structure, but it has some features of both unitary as well as what? It has both the features of unitary features and is sometimes called a quasi-federal state. This is a hybrid legal system. Now, federal government and unitary government. Federal means two levels of government, central government and state government, with political powers shared by two levels of government. Constitution rigid and codified, two types of law, state government and central government. Unitary government only one, that is central government or national. Political power held by central government only, and constitution is flexible and uncodified. Only one set of law that is uniform for the whole country. Now, in short, Constitution of India. Constitution has given power to the Parliament to make laws as per Article 245 and has distributed it in three lists which are known as Union, which is central, state, and joint or concurrent according to Article 246. Statutes or laws made by Parliament. Parliament is the ultimate law-making body and it can make, amend or repeal laws. It means that it can pass, change or end laws. Okay, now precedents or judicial decisions according to Article 141. Supreme Court is the highest authority in India. It means all the judicial decisions passed by Supreme Court will apply to the whole of India, and it is called the common law. Which one? Precedents or judicial decisions applied by the Supreme Court. Customary law, customs and usages. Law based on custom and usages is called source of law. Okay. Now, apart from that, the Government of India Act 1935 passed by the Parliament of the UK in the precursor of the Constitution of India. It defined the characteristics of the government from unitary to federal. Okay, then 1937, Federal Court was established. Powers were distributed between center and state to avoid any disputes. The Federal Court operated for 12 years and held roughly 151 cases. India's current apex court, that is the Supreme Court of India. Now, 1950, the Constitution of India 1950 is the foremost law within which our democratic system works, and our laws are made for the people by the people. Income tax implemented by the central government through this Ministry of Finance, levy of stamp duty, that is both central government and state government. Now there's a process of making law. When a law is proposed in the parliament, okay, it is called a bill. When a law is proposed in parliament, it is called a bill. After discussion and debates, the law is passed in Lok Sabha. Thereafter, it has to be passed in the Rajya Sabha, then must obtain the assent of the President of India. Okay, finally the law will be notified by the government in the publication called the Official Gazette of India. The law will become applicable from the date mentioned in the notification as the effective date. Once it is notified and effective, it is called an Act of Parliament. Now, remembering this, when a law is passed in the parliament, it is called a bill. Okay, after discussion and debate, the law is then passed in Lok Sabha. Thereafter, it has to be passed in the Rajya Sabha. It then must obtain the assent of the President of India. Finally, the law will be notified in the government in the publication called the Official Gazette of India. The law will become applicable from the date mentioned in the notification as the effective date. And once it is notified and effective, it is called an Act of Parliament. So, what is the process of making an act? From law to bill to act. Okay, so 3 steps basically. First is law. Second is bill. Then it is act. Okay, nice. Now, there are types of laws. Now, without looking at it, we can understand that there are 4 types of laws. Okay, criminal law, civil law, common law, principle of natural justice. Okay, so C3N. 3 times C and 1 N. Now, criminal law. Okay, so criminal law is concerned with laws pertaining to violations of the rule of law or public wrongs and punishment of the same. Criminal law is governed under the Bharatiya Nyaya Sanhita BNS and the Bharatiya Nagrik Suraksha Sanhita 2023 BNSS. Now this was updated. Earlier it was known as IPC, Indian Penal Code, and CRPC, the Code of Criminal Procedures. IPC 1860 and CRPC 1973. Okay, now it was updated and that is why the name changed as Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita. The Bharatiya Nyaya Sanhita BNS defines the crime, its nature and punishments, whereas the Bharatiya Nagrik Suraksha Sanhita 2023 BNSS defines exhaustive procedure for executing the punishments of the crime. So basically, nature and punishment by IPC or by BNS, Bharatiya Nyaya Sanhita. CRPC executes and procedure for executing punishments is Bharatiya Nagrik Suraksha Sanhita 2023 BNSS. Okay. Now, murder, rape, theft, fraud, cheating and assault are some examples of criminal offences under the law. So, I hope that criminal law is quite clear to all of you. Let us come to the next, which is civil law. Matters of disputes between individuals or organizations are dealt under civil law. Civil courts enforce the violation of certain rights and obligations through the institution of a civil suit. Civil law primarily focuses on dispute resolution rather than punishment. So, if the question states that if which law focuses on dispute resolution rather than punishment, your answer would be civil law. Okay, the act of process and the administration of civil law are governed by the Code of Code of Civil Procedure 1908, that is CPC. Okay, civil law can be further classified into law of contract, family law, property law and law of tort. So there are 4 further classifications of civil law. Okay, so this one needs to be written: law of contract, family law, property law and law of tort. So CFPT. Okay, law of contract, family law, property law and law of tort. Some examples of civil offences are breach of contract, non-delivery of goods, non-payment of dues to lender or seller, defamation, breach of contract and disputes between landlord and tenant. Nice. Now, common law. What is common law? A judicial precedent or a case law is common law. So, a judicial precedent or a common law or a case law is common law. A judgment delivered by the Supreme Court will be binding upon the courts within the territory of India under Article 141 of the Indian Constitution. The doctrine of stare decisis is the principle supporting common law. It is the Latin phrase which means to stand by that which is decided. The doctrine of stare decisis reinforces the obligation of courts to follow the same principle or judgment established by previous decisions while ruling a case where the facts are similar or on all 4 legs with the earlier decision. Principles of natural justice. Natural justice, often known as just natural, deals with certain fundamental principles of justice going beyond written law. Nemo judex in causa sua, literally meaning no one should be made a judge in his own case. And its rule against prejudice, audi alteram partem, literally meaning hear the other party or give the other party a fair hearing. And reasoned decisions are the rules of natural justice. A judgment can override or alter a common law, but it cannot override or change the statute. Enforcing the law. Now, these four things, I hope that it is quite clear from reading itself. Okay, now criminal law, civil law, common law, and principle of natural justice. Now these two things are you have to remember it, that common law, it follows the doctrine of state decisions, means to stand by that which is decided, and principle of natural justice, also known as just natural, it follows two laws. Okay, nemo judex in causa sua means no one should be made a judge in his own case, and audi alteram partem means hear the other party or give the other party a fair hearing. These are the things, these are the doctrines which you should remember it, and you will be framing it in your answers when asked. Okay, enforcing the law, how you will enforce the law? After a law is passed in parliament, it has to be enforced. Somebody should monitor whether the law is being followed. This is the job of the executive. Now executive means to see that it is enforced. Enforcing the law is basically to execute the law. Okay, depending on whether a law is a central law, state law, the central or state government will be the enforcing authority. For this purpose, government functions are distributed to various ministries. Some of the popular ministries are the Ministry of Finance, the Ministry of Corporate Affairs, the Ministry of Home Affairs, the Ministry of Law and Justice, and so on. These ministries are headed by a minister and run by officers of the Indian administrative and other services. The government of India exercises its executive authority through a number of government ministries or departments of state. Okay, so the government of India exercises its executive authority through a number of government ministries, department of state. Now these are the things which department of state and government ministries, these you need to remember. Okay, let's see. A ministry is composed of employed officials known as civil servants, that is basically Indian administrative services, Indian revenue services, Indian economic services, and many more, which will be seeing we further. Okay, and is politically accountable through a minister. Okay, nice. Most major ministries are headed by cabinet minister. Okay, cabinet minister who sits in the union council ministers and is typically supported by a team of junior ministers called the ministers of the state. Okay, so cabinet minister, under cabinet minister are a team of junior ministers called the ministers of state. Okay, cabinet minister sits in the union council of ministers and is supported by a team of junior ministers called the ministers of state. For example, the income tax act is implemented and enforced by the Ministry of Finance through the central board for direct taxes, coming under the department of revenue and is administered by the officers of the Indian Revenue Service. Okay, we will see some of the major ministries. Okay, guys. Now, Ministry of Finance. Ministry of Finance or Vitta Mantralaya is a ministry within which the government of India concerned with the economy of India, serving as the treasury of India. Okay, Ministry of Finance, Vitta Mantralaya is the treasury of India, serves as treasury of India. In particular, it concerns itself with taxation, financial legislation, financial institutions, capital market center, and state finances, and the union budget. As a chartered accountant, many of your day-to-day work. Okay, nice. Okay, nice. This ministry. So, it's important for that many ministers have preferred to hold the portfolio of finance minister. Also, one of the major functions of this finance minister is the presentation of the union budget. Okay, so presentation of union budget is also a function of what? Vitta Mantralaya. Okay, this annual event is eagerly awaited by professionals and the common man, as it provides for the rates of taxes and budget allocation for the ensuing year. Okay, nice. Constitution of the Ministry of Finance. Now, basically, it is the apex controlling authority and four central civil services, namely Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, and Indian Civil Accounts Service. Basically, RAEC, right? RAEC, Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, Indian Civil Account Service, RAEC. Once again, Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, Indian Civil Account Service. Also the apex controlling authority of one of the central commerce services, namely Indian Cost and Management Account Service. Okay, nice. Now, departments under Ministry of Finance. 6 departments are there under Ministry of Finance. Department of Economic Affairs, Department of Expenditure, Department of Revenue, Department of Financial Services, Department of Investment and Public Asset Management, Department of Public Enterprises. Now, mnemonic trick coming over here. EERFIP. Department of Economic Affairs, Department of Expenditure, Department of Revenue, Department of Financial Services, Department of Investment and Public Asset Management. Okay, Department of EERFIP, Department of Public Enterprises. Very good. Ministry of Corporate Affairs. Okay, nice. What is Ministry of Corporate Affairs? We are in the Ministry of Finance, and under Ministry of Finance, we have Ministry of Corporate Affairs. Okay, nice. So, Ministry of Corporate Affairs is an Indian government ministry primarily concerned with administration of the Companies Act 2013, the Companies Act 1956. Earlier it was 1956, now it is 2013, okay? The Limited Liability Partnership Act 2008 and the Insolvency and Bankruptcy Code 2016, responsible mainly for the regulation of Indian enterprises in the industrial and service sector. The ministry is mostly run by civil servants of the ICLS cadre. These officers are elected through the Civil Services Examination conducted by the UPSC, Union Public Service Commission. Nice. I know you must be knowing. The highest post, Director General of Corporate Affairs, DGCOA, is the fixed at apex scale for ICLS. Now, Ministry of Home Affairs, Griha Mantralaya, is the Ministry of Government of India. We know it nice. As an Interior Ministry of India, it is mainly responsible for the maintenance of internal security and domestic policy. The Home Ministry is headed by Union Minister of Home Affairs, Union Minister of Home Affairs, okay. What is the Department of Ministry of Home Affairs? DIJHOS, nice. Department of Border Management, Department of Internal Security, Department of Jammu, Kashmir and Ladakh Affairs, Department of Home, Department of Official Language, and under which three more things are there, three more departments are there, that is THC, we will look forward to it, and Department of States, nice. Once again, Departments of Ministry of Home Affairs, BIJHOS, Department of Border Management, Department of Internal Security, Department of Jammu, Kashmir and Ladakh Affairs, Department of Home, Department of Official Language, Department of States. Now, Department of Official Language, THC, that is Central Translation Bureau, then Central Hindi Training Institute and Directorate of Census Operations. Once again, THC. Departments under Official Language, THC. Central Translation Bureau, Central Hindi Training Institute and Directorate of Census Operations. Nice. Now, Ministry of Law and Justice. What is Law and Justice Ministry? In the Government of India, is a cabinet ministry, deals with the management of the legal affairs through the Department of Legal Affairs, L. Legislative activities through the Legislative Department, once again L. Administration of Justice in India through the Department of Justice, J. So LLJ. The Department of Legal Affairs is concerned with advising the various ministries of the central government, while the Legislative Department is concerned with drafting of principal legislation for the central government. Okay, LLJ. Nice. So, departments under Ministry of Law and Justice. Department of Legal Affairs, Legislative Department, Department of Justice, LLJ, Department of Legal Affairs, Legislative Department, Department of Justice. Nice. Securities and Exchange Board of India, SEBI. Regulatory body, Securities and Commodity Market in India, under the ownership of Ministry of Finance within the Government of India. It was established on 12th April 1988 as an executive body and was given statutory powers on 30th January 1992 through the SEBI Act 1992. Reserve Bank of India, RBI, is India's central bank and regulatory body responsible for regulation of the Indian banking system. It is under the ownership of Ministry of Finance, Government of India. It is responsible for the control, issue and maintaining supply of the Indian rupee. It also manages the country's main payment systems and works to promote its economic development. BRBNM, Bharatiya Reserve Bank Note Mudran. BRBNM, Bharatiya Reserve Bank Note Mudran, is a specialized division of RBI through which it prints and mints Indian currency notes, INR, in two of its currency printing presses located in Nashik and Devas. Nashik, Western India, and Devas, Central India. RBI established the National Payments Corporation of India as one of its specialized division to regulate the payment and settlement systems in India. Deposit Insurance and Credit Guarantee Corporation was established by RBI as one of its specialized division for the purpose of providing insurance of deposits and guaranteeing of credit facilities to all Indian banks. Nice. Insolvency and Bankruptcy Board of India, IBBI. Regulator for overseeing insolvency proceedings and entities like Insolvency Professional Agencies, IPA, Insolvency Professionals, IP and Information Utilities, IU in India. It was established on 1st October 2016 and given statutory powers through the Insolvency and Bankruptcy Code, which was passed by Lok Sabha on 5th May 2016. It covers individuals, companies, limited liability, partnership and partnership firms. The new code will speed up the resolution process for stressed assets in the country. It attempts to simplify the process of insolvency and bankruptcy proceedings. It handles the cases using two tribunals like NCLT, National Company Law Tribunal, and Debt Recovery Tribunal. Those tribunals are there. Nice. Structure of the Indian judicial system. When there is a dispute between citizens or between citizens and the government, these disputes are resolved by the judiciary. Judiciary क्या करता है? Judiciary dispute resolve करता है. Okay. Functions are FDI. Why FDI mnemonic? Let's see. Firstly is the fairness. F, fairness. D, dispute resolution. I, interpretation of the acts and codes. Once again, or RDP you can say. FDI or RDP you can say. Functions of judiciary system in India. Regulation of the interpretation of acts and codes. Dispute resolution, promotion of fairness among the citizens of the land. In the hierarchy of courts, the Supreme Court is the top. We know it, nice, followed by the High Court and District Court. Decision of a High Court is binding in the respective state but are only persuasive in other states. Decision of the Supreme Court are binding in all high courts. Under Article 141 of the Indian Constitution, in fact, the Supreme Court decision is the final word of the matter, okay? So firstly is the Supreme Court, then it is the High Court, then it is the District Court, and then it is the Metropolitan Court. So SHDM. Nice. Supreme Court is the apex body of the judiciary. It means it was established on 26th January 1950. The Chief Justice of India is the highest authority appointed under Article 126. The principal bench of the Supreme Court consists of 7 members, including the Chief Justice of India. Presently, the number has increased to 34, including the Chief Justice of India, due to the rise in the number of cases and workload. An individual can seek relief in the Supreme Court by filing a writ petition under Article 32. Nice. Article 32. High Court. The highest court of appeal in each state and union territory is the High Court. Article 214 of the Indian Constitution states that there must be a High Court in each state. The High Court has appellant, original jurisdiction and supervisory jurisdiction. Okay, High Court has 3 things. Okay, nice. Appellant, original jurisdiction, supervisory jurisdiction. Nice. Appellant, original jurisdiction and supervisory jurisdiction. However, Article 227 of the Indian Constitution limits a High Court's supervisory power. In India, there are 25 High Courts, 1 for each state and union territory. I mean, 1 for each state and union territory. Nice. 1 for each state and union territory and 1 for each state and union territory. Okay, nice. 6 states share a single High Court. An individual can seek remedies against violation of fundamental rights in High Court by filing a writ under Article 226. Which is the oldest High Court in India? Who does not know? Calcutta High Court, established on 2nd July 1862. District Court. Nice. Below the High Courts are the District Courts. The courts of district judge deal with civil matters, that is contractual disputes and claims for damages, etc. The Court of Session deals with the criminal matter. Under pecuniary jurisdiction, a civil judge can try suits valuing not more than rupees 2 crore. Jurisdiction means the power of control. Courts get territorial jurisdiction based on the areas covered by them. Cases are decided based on the local limits within which the parties reside or the property under dispute is situated. Metropolitan courts. Metropolitan courts are established in metropolitan cities in consultation with the High Court where the population is 10 lakh or more. Chief Metropolitan Magistrate has powers as Chief Judicial Magistrate and Metropolitan Magistrate has powers as the Court of Magistrate of the first class. So the topic was structure of the Indian judicial system. So the structure of Indian judicial system. Functions are 3 FDI. First is the interpretation, regulation and regulation of the interpretation of acts and codes, dispute resolution, promotion of fairness among the citizens of India. Okay, nice. After that, we have 4 courts. Supreme Court, the highest apex court, High Court, then District Court, then Metropolitan Court. Okay, so 4 Supreme Court, High Court, District Court and Metropolitan Court. Nice. A chartered accountant should be aware of law because he has to advise management and clients on legal matters of a basic. Okay, nice. Not a main source of law. What were the main source of law? The Constitution. Okay. Then the precedents. Then the precedents and laws. Okay. And then what are the statutes? The statutes were there. Okay. The customs and usages. That is customary law. Let us see if I am wrong. Okay. Constitution of India, statutes or laws made by the Parliament, Presidents or judicial decision and customary law. I was right. Okay, nice. So, what is not legal textbook? Okay, nice. In India, we follow federal system of government means powers are distributed between center and state. Constitution of India was adopted 1949. Don't mark 1950. Okay, 1949. Adopted. It was enforced in 1950. The law concerned with violation of rule of law and punishment is the same called criminal law. Okay. Not an example of civil law. Traffic offences. बाकी सारा civil law है. When a law is proposed in Parliament, it's called a bill, not a Department of Ministry of Finance, Department of States, because EERFIP were the departments of Ministry of Finance, okay? Department of what? Department of Economic Affairs, Department of Expenditure, Department of Revenue, Department of Financial Asset Management, Department of Investment and Public Asset Management and Department of Public Enterprises, okay? You can check if I am wrong. and tell me in the comments, okay? Courts get territorial limits based on either A or B, the local limits within which the party resides, the local limits within which the government property, within which the property under dispute is located. What is the significance of the Supreme Court and High Court in the Indian judiciary? What do they mean in stand by law? Also elaborate the process of making law. Okay, nice. Bye bye. Subscribe. Bye bye, guys. Bye bye.